Red Apple Media Podcast Network presents This is Protecting America. Now, here's Emmy-winning journalist Rita Cosby.
And welcome to another edition of Protecting America. I'm Rita Cosby. Well, our nation and the world were horrified by the assassination of conservative leader Charlie Kirk. And the next court hearing for his accused assassin is set for October 30th. So how solid is the case against 22-year-old Tyler Robinson, who could face the death penalty if convicted? Well, joining us on this and so much more is former federal prosecutor Doug Burns. Doug, great to have you here.
Thanks. Great to be here.
Doug, how strong is the case against Tyler Robinson?
Well, with the standard legal caveat, which is important, which is, we don't prejudge a case, and we respect the idea that someone's innocent until a jury says they're guilty. The reality is that the case is extremely, extremely strong, and here's why. Without any confessions, we'll start with that, you have all kinds of very strong evidence. You have DNA on a screwdriver and a towel that the gun that was recovered was wrapped in. That's colossal. You're going to have so much surveillance. As we learned from many of the recent cases, we live in a world of cameras, and it's just unbelievable what gets captured. So you have that. And then, of course, you go to the fact that he confessed to his significant other. And the reality is, reading your mind, you're going to ask me, well, wait a minute, will that be admissible in court? It will be admissible, and here's why really quick. Normally, that's what you call hearsay. Witness comes in, says, I'm the significant other, and he told me that he killed the person. That's hearsay. But it's an exception to the hearsay rule when it's a statement by the defendant against their penal interest without getting all in the weeds. The bottom line is it will be put before the jury.
Those comments, especially to his significant other, they're absolutely damning. And they're at the moment right after the shooting, as we understand. So that's even more important, too. It's not like months later. It's not like years later. It seems like minutes, maybe hours, but minutes later.
Well, you're a natural lawyer because the point is, any kind of contemporaneous statements right at the time. We have another exception to the hearsay rule. Inapplicable, but I think the listeners will find it interesting, which is an excited utterance like, oh, my God, look at that. The point is you're not going to lie because you didn't have time to reflect and contemplate lying. So here, you're right. It happened right around the time of the events. It's going to be an extremely strong case. I view it, honestly, as very analogous, and this is just shop talk, legal shop talk, analogous to the Kohlberger case. Jumping way ahead of my skis uncharacteristically. And I think I told you this before, Rita. I think you may eventually see a situation where there is not a trial, believe it or not, okay? Just looking into my crystal ball, like in Kohlberger.
Now, in the Kohlberger case, as we know, that was the Idaho case where he admitted finally that he did it. But what was interesting in that case, he never said a motive. I mean, we still at this point don't really know a full-blown motive to that case. And in that case, here there seems to be, I think this case, this is just as a layman, Doug Burns, seems even stronger by far because you've got the communications, you've got the surveillance footage, putting him at the scene. There seems to me, this one seems overwhelmingly much more solid and many more layers to it.
No, couldn't agree more. In other words, in Kohlberger, what was interesting, again, just shop talking legal X's and O's, which, by the way, minor editorial sometimes comes across as insensitive, but, this is what we do for a living. It's just X's and O's. In Kohlberger, it was a horse race for quite a while, okay? They had one DNA speck, on a sheath that a knife was in, but there were ways to sort of challenge that possibly, and it really was much, much closer than this one. And again, I think when the dust settles, and it's going to take time, you saw it today, that the decision whether to waive the preliminary hearing wasn't even made today, coming back October 30th. The defendant will be required to be present, which will, obviously create a lot more media interest that particular day. Nothing wrong with that. And the fact of the matter is, at that point, they'll decide whether they set a preliminary hearing date. Just for the for the listeners, it's interesting. Usually what happens is you can insist on a preliminary hearing, but then the prosecutors indict the case in the grand jury, and that removes your right to the hearing because the grand jury found probable cause. But in Utah, again, without getting too much in the weeds, they don't use the grand juries all that much, and they essentially use a preliminary hearing system. Now, at a preliminary hearing, the government, the state, has to simply show by probable cause that there's probable cause to believe. It's completely and totally a formality. The judge will, it's 100% certified that there's probable cause. However, as many experts correctly pointed out today, I wasn't one of them, but joking aside, the fact of the matter is that a preliminary hearing can be an excellent opportunity for the defense to force the state, to put out a lot of the information about their case to ostensibly help them prepare better.
It's interesting because exactly that's right. A way to sort of get a roadmap of where they're going. On the other hand, there seems to be already a lot of stuff out there that already came just when they arrested him. I mean, there were all the press conferences with a lot of the details that you just talked about, aptly at the top. So do you think they need to really even put out much more in this preliminary hearing since a lot of it's already out there because this was such a high-profile case?
Well, now you're raising another nuance, and you're right, and that's a great nuance. And the nuance is that, prosecutors who realize that it's very, very, very strong, they can just put in the most bare bones presentation. Hearsay is admissible in a preliminary hearing. That's important to note. Hearsay is admissible in grand jury. Can't be abused, can't be used as the main, focus of the proof. But the bottom line is, as a federal prosecutor, time and time again, I would put in a case agent, and they would relate different aspects of the case through hearsay. A witness told me this, and another witness told me that. And so they'll be able to do that as well. Sort of to your observation, and you're so right, they will call a couple of law enforcement people, keep it real bare bones, real simple. But the bottom line is, let's just use our common sense here. We recovered his DNA on a towel that the weapon, was on. We recovered a screwdriver right there with it, has his DNA. Again, we have all of these text messages. They can put them up on a screen, overhead projector, like when we were kids. Now it's a little more sophisticated, but you get the point, and they will see all of the texts to the roommate, and the case will be bound over for trial. Other experts have said related point. Maybe it's a drop too glib. The defense lawyer's job is to really just save the life of the defendant. But glibness aside, that's actually fairly accurate in my opinion, because again, without prejudging it, this case is very, very, very strong and way stronger than Kohberger at this stage of the proceedings.
You talked about the hearings because he would appear, as you mentioned, in the next one, the October 30th. Mm-hmm. And in the one that took place this week, you just heard his voice. And you saw him, though, in the first one, obviously, right after he was arrested. You know what stunned me, Doug? He just seemed kind of detached, emotionless. I mean, we'll see how in October, but he just sort of seemed kind of nonchalantly sitting there in the first one where we saw him for the first time. It's interesting, too, and I juxtapose that. I put that with the messages that where he was talking about with the gun at the time right after the shooting and those contemporaneous messages, right? He's writing out and talking about he's worried about his grandpa's gun. He's worried his grandpa's going to be mad. He's not worried about the shooting. He's worried about getting the gun so his grandfather won't be mad. He doesn't seem concerned that he just assassinated somebody.
Yeah, but what's interesting is you have two sets of double-edged swords. Very interesting. On the one aspect of the discussion is, was he insane at the time of the crime? Okay, that's going to be extremely difficult because, as you just said, you have all kinds of messages that make it seem that he clearly understood what he was doing, and without getting into the law school stuff about the McNaughton test and right from wrong and all of that. But the reality is that's going to be hard. But then you get into the next one, which is, can he meaningfully understand the charges now after the crime? Can he meaningfully assist in his defense? So some of that flat affect creates arguments kind of all over the place. Excuse me. But jumping ahead, I don't think an insanity defense will be successful in terms of at the time of the offense, and I don't think any psychiatrist is going to say that he can't understand the case now and go forward. But your observation is very interesting, which is when you see somebody who just seems to be completely detached from everything, it definitely kind of raises a bit of a red flag.
Yeah, it definitely does. And obviously, look, to kill somebody, you have to have, obviously, a screw loose. But it's interesting. After the shooting, he knew enough to go hide the gun. He knew enough to change his clothes. He knew enough to, hide the gun in the towel and to try to go back and get it again. And so, I mean, the show's just obviously also very prepared, cunning. He talked about hating Charlie Kirk. I mean, to me, you hit on the issue of insanity. It seems so organized prior to. He knew enough to try to cover his trails afterwards, how to slip away, which direction to go. I mean, there's so much planning here that, to me, I would be stunned if any level of insanity would work, right?
Yeah, the state should get a transcript of this show and just make that exact argument to the court. I'm not blowing smoke at you. That's exactly how you argue it. Your Honor, if you look at all of the planning, the preparation, the calm maneuvers that were made here, that clearly defeats any notion of mental disease or defect, that would vitiate mens rea or intent to do the crime, et cetera, et cetera. Exactly the way you just argued it.
And he also seemed frustrated that he was worried he could get caught. In other words, I got to try to slip away. I got to stay low. I got to do this. I mean,
let me jump in on that. That's key, because that's very important. Because if you don't know right from wrong, you don't know what you're doing. Back to the law school question, they say when you shot the person, you literally thought you were squeezing a lemon, right? Then there would be nothing about being concerned about being caught. Is the exact point.
Exactly. You're worried about being caught because a crime was committed.
You appreciate what you did. Exactly.
How key is the roommate going to be? Because to me, that's a big part of this. This roommate who seems to be, by reports, cooperating with authorities and seems to be unaware of anything prior to. Because if you believe, and I always, you've seen crazy cases too, who knows? I've had people say, hey, what if it was all one big setup and maybe the roommate knew? But so far, there doesn't seem to be any evidence of that. But if indeed the roommate genuinely had no idea and then was learning it in the messages, that person is going to be a very helpful piece of information from the case perspective, right?
Yeah, but look at this key distinction, which is absolutely critical. Assume hypothetically that you had a case like this, and the roommate simply spoke to the person, to the defendant on the phone, and then came into court and said, he told me X and he told me Y. This is all memorialized, okay? So there's no issue about, the credibility of that witness, because everything is on paper in, texts or whatever the communications were. So it removes the drama of, are we going to believe that person? The stuff is plain as the nose on everybody's face. So the point is, and the reason I mention that is because in a case like this, a witness can go south, another sort of X's and O's around the conference room's term that we use. Going south means they come in and start hedging. He really didn't confess to me. Stuff like that. But again, this is in writing.
Yeah, exactly. It's all there. You don't even have to go into the credibility of the person because it's really the words from the. What about also prior to some of these, dark chat rooms that we've heard of too, that other people have been involved, the Discord, that maybe were aware of him preaching hate towards Charlie Kirk. Obviously, we know that the FBI director is looking in to seeing if anybody potentially could be culpable.
Yeah, well, that starts getting into some tricky legal distinctions that I'm happy to talk about briefly. The tricky legal distinctions are that, believe it or not, mere knowledge that something may take place does not automatically create criminal liability. You can have a completely separate moral discussion, obviously. So if somebody tells me tonight, hypothetically, I'm going to kill somebody next week, I should really morally examine the idea that I should step forward with that. But legally, I don't think it creates criminal liability, so that's tricky. But then there's, exceptions to every rule where it's more overt, and then you also get into stuff about, ostensibly hiding information. So in my little example, the point is I know that somebody's going to kill somebody, and then they come to me and say, did you know about it? And I say, no. Well, now I've lied and I've obstructed the investigation, and that's a separate discussion. But again, they're looking very, very closely, very, very hard to your exact question, which is who may have known and what exactly did they know in advance and so forth. But again, this seems like pretty much of a lone actor thing. The roommate, incidentally, and I don't necessarily have this mastered, so I'd be curious your understanding of it, but I think the roommate was actually a little bit surprised by everything. No?
Yes, that's what it sounded like. Yeah. It sounded like from the messages, did
right.
you do this?
Exactly.
It seems like truly seemed shocked, at least
right.
in writing.
Yeah, that's the way I understood it. And back to your excellent word, contemporaneous. So the point is, right at that time, the roommate's saying, oh, my God, you really did this, So there was no question that the person was surprised and had no time to, think about saying anything other than the truth is the point.
I have an interesting legal question. What happens with the parents? How pivotal could they be potentially as witnesses? And the reason I bring that up is it's the mother who said, according to authorities, saw his picture, with the surveillance footage that everybody saw when the FBI put it out, and said, boy, that looks like my son. Then also the father agreed, and they both either together or separately approached the son and said, and then finally, apparently, he said something indicating that he may have done it, obviously. And then the father reached out to somebody in the sheriff's office that ultimately worked with the surrender of the guy.
Well,
so how key could the parents be, things that he may have told them when they reached out immediately and said, hey, that looks like you in the surveillance footage?
Yeah, well, first of all, on the liability question, it's sort of the opposite of the liability situation, which is where you assist them in remaining a fugitive, you know what I mean? And that gets into all kinds of really tricky questions about did you participate in hiding him? Were you asked by law enforcement where he was and you weren't truthful, stuff like that. So here it's the opposite of that because they essentially turned him in.
Yeah, and by the way, how amazing is that the parents, it's
the
extraordinary.
Father was in law enforcement apparently for 27 years, which is interesting. But to your other question, very important, which is, what confessions might he have done to his parents, which sets up a very interesting moral situation. I've been in cases with relatives. It's U.S. Department of Justice policy, by the way, not to necessarily force a relative to test against another one, but the exception is at a level of a murder case, by the way. Okay. So again, I don't know what, A, did he make oral admissions to them? B, did he text them? Who knows, Rita?
Yeah, you have to wonder, right? Is there maybe even more to the story, too, than we know of, or more evidence out there? So where does the case lead? You talked about, obviously, the next hearing is going to be October 30th, Doug.
Right.
What the role of the attorney now is, as you said, just try to get to anything that, is it tainting the evidence? Is it saying, well, maybe the DNA isn't right, or that wasn't him, or just trying to work on getting some sort of a plea deal? Where do you see this going?
Yeah, the first thing is the ballistics, okay? The weapon that was recovered, there's going to be a lot of, analysis of that. And if, in fact, it's airtight that that's the weapon that was used in the murder, it's going to be extremely, extremely hard to defend. But you certainly have to, you owe the client, pushing that as far as you can, as far as really drilling down onto the facts. But the overall question, again, goes to what I said earlier about moral, factual, and legal guilt. And people find this interesting. Some countries, by the way, they have a verdict of not proven. So it's guilty, not proven. And that takes away the idea on a U.S. not guilty verdict, O.J. Simpson, like, what are you talking about not guilty? He did it. Well, the point is, he was factually guilty. He was morally guilty. Was he legally guilty? That's what everybody debates because they made a lot of mistakes during the trial. They tried tried the case completely and totally wrong. That's another seminar, another podcast you don't have to get into. I've read many books about the case, but the point is he wasn't legally guilty because they blew the case. One of their witnesses got caught flat out in a direct lie, a detective. If I'm trying a drug case in federal court and my DEA case agent gets caught in a direct lie, I expect to lose that case every single time. So here, to your question, not avoiding it, no, you got to prod and push, because in our system, everybody's entitled to a trial, because if corners are cut, and things aren't done properly, then you can actually convict somebody who didn't do it. So you test the system. But make no mistake about it, when this lawyer's head hits the pillow, she's concerned about how hard it's going to be to defend this case, and that's why I think you may see a guilty plea down the road. And by the way, very important point that you and I have discussed before, the death penalty part is a separate hearing, okay? It's a bifurcated or split proceeding. One is the guilt or innocence part. Two is death penalty. The reason I mention that is because people might be saying, well, wait a minute, he wouldn't plead guilty to the death penalty. You don't plead guilty to the death penalty. You plead guilty factually that you did the crime, and then you have a separate hearing on the death penalty. The state gets to try to put in what they call aggravating factors, the defense mitigating factors, and then the jury decides death penalty or not. And I believe, not 100% on this, but I believe the judge may have the final decision on whether or not the death penalty is imposed. And very, very important point, I'm telling you right now, crystal ball prediction, and it's not any big crystal ball prediction, because I believe that Rita Kirk has already stated her opposition to the death penalty, either A, in general, or B, as applied to this case as well. I don't know.
Actually, she actually didn't, which is interesting, Doug. What she said was, I've forgiven this guy, but she said in terms of punishment, I leave that up to the prosecutors. I leave that up to the court.
But my crystal ball is, believe it or not, and I could be dead wrong. That's why they call it a crystal ball. I could see her possibly saying that she wasn't pushing for it in the case. We'll see.
Yeah, we'll see. You're right, because it's an interesting. You're right. It's really, when she said that at the service, right, that she forgave him. Some people are making the distinction. She's still saying, legal system, do your part. Okay. But it's hard to tell. To your point, it is. It's a little right.
And I could see her possibly being against it. On whatever grounds and so on and so forth. I mean, the fact that she forgave him.
That was
just
extraordinary.
Incredible, extraordinary moment. But it just showed, just the unbelievable, high-class display of character. Unbelievable.
Yeah, absolutely. I mean, what an unbelievable, amazing woman and person to find that after so soon after her husband's assassination. By the way, in Utah, as you know, there are a couple forms of death penalty, but one of them is firing squad. So if he pleads, does that mean automatically death is off the table, or no? It's still up to the judge, but it certainly carries influence, right? Or is it part of the
thing.
or is it clearly going to be part of the deal as, hey, let me plead, but but the deal is life?
Well, yeah, in Koberger, they plea bargained away the death penalty. I said, it's funny because I was thinking about this before joining you for this discussion. I had said in media that, there's no way that they're going to take the death penalty off the table. I think I was correct, but at the same time, you never know. The point is, so the flowchart options or multiple choice test options are, A, they offer them a plea of guilty, and they remove the seeking of the death penalty, and then the judge gives them life imprisonment, without parole, end of story. Okay, B would be he pleads guilty and then takes his chances at the separate sentencing hearing, which is the state saying you can plead guilty, but we're making absolutely no commitment whatsoever with respect to the sentence, and we're going to have a sentencing hearing, and we're going to aggressively try to show aggravating factors as the prosecutors, and you can try as the defense to do mitigating ones. Interestingly enough, real quick, and you know this because we discussed it, on the aggravated murder statute in Utah, they have a whole laundry list of things. Virtually all of them do not apply without getting into it. But then there's the one critical one, and this is the one they're going forward on, which is that he put others in danger besides just the victim. And one of the guests on a media segment that I observed made a really good point, which is, of course, he put others in harm. You could have a stampede. People could be trampling all over each other. So I think they're going to be able to establish that as an aggravating factor. But again, who knows what the mitigation they might try to put in, and, we'll see whether the judge imposes the death penalty. On the firing squad, the primary methodology is lethal injection, but you're absolutely right. Firing squad can also be in play.
Yeah, it's really going to be an interesting case, and to see where it goes. It does seem that the evidence is so strong. But we'll see where everything heads, and we'll see, what he does, just like you said. It looks like he's obviously confessed. It looks like obviously in some form he has, and also with his parents and in writing and the evidence. But obviously there's always twists and turns. But boy, oh boy, going back to even what you said about Rita Kirk, what an amazing human being. Boy, I think the whole world was blown away by her courage and just her grace under that moment. Extraordinary. I mean, really extraordinary. Doug Burns, thank you. And everybody, be sure to subscribe and share to this really powerful podcast. Doug, I always learn so much from you and always love having you on. Thank you, Doug.
My pleasure. Thank you, Rita.
And everybody, I'll be back soon with another great edition of Protecting America. And of course, you can catch me every weeknight, 10 p.m. to midnight on the legendary WABC Radio. This is Rita Cosby, and thanks for all you do to protect America.